Let me set us up again.
If it helps, Your Honor, I just saw the message pop up on my screen that it's being live streamed.
All right, thank you so much. You know, my computer is doing funny things this morning. And we shall see what's going on. Let me see. We do have it now. All right, let me go back in with the customizations. Hopefully we will work this time. And it takes a while for it to save, so everyone just give me a moment. Okay, so hopefully we have it now. All right, everyone, welcome to the 187th District Court. As I previously stated, it's a Monday, but we're going to make it a great Monday because it's the day for new beginnings. Here are the rules. You are in a courtroom. You are not allowed to do anything on this screen that you could not do if you were physically in the courtroom. So that means if you're at work, you need to let your employer know. You need to take a break so that you can appear on Zoom. Please do not move throughout the Zoom because it makes everyone nauseous, so find a stationary place. To all defendants or those who are accused of offenses, you are not allowed to let your screen go black. So do not stop your video. If you stop your video, what's going to happen is you're going to be required to appear in court. Now, sometimes I do know that people who are on their phone, their video will stop if they're signing paperwork. So that's the only excuse for your video to be stopped. But people who are at the Bexar County Jail, that does not apply to you. Everyone at the Bexar County Jail, you're not allowed to use the chat box. If you use the chat box, you will be sent back. And what will end up happening, because you know they're shorthanded, we'll probably see you in 30 to 60 days. To everyone on this Zoom screen, this is not the Bachelor, this is not the Bachelorette. You're not allowed to pick up dates on this Zoom screen. You need to do that on your own time. Ms. Ferguson is the court coordinator. If anyone has any plea agreements, no matter how small you think that agreement is, you need to put it in the chat box to the court coordinator. She's listed as Ferguson coordinator. Do not text her, email, chat her, call her, asking for a continuance. I'm the only person who can do that. If you wish to Zoom to another courtroom, you're more than welcome to Zoom to another courtroom. However, if you Zoom to another courtroom and your name is called, you will be placed at the end of the list. I'm going to open up the breakout rooms. When I open up the breakout rooms, it will invite everyone to go to a breakout room. Please do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. Again, do not go to any breakout room unless I specifically call you by name and assign you to a breakout room. To all attorneys, I'm going to call your name. This is the order in which you'll appear. To those who are accused or defendants, you will not hear your attorney's name. I'm sorry, if you do not hear your attorney's name, it is because they're Zooming in another courtroom or because they had to appear in person. So please do not raise your hand and say, I didn't hear my attorney's name called, because your attorney is probably Zooming in another courtroom. Trust me, you will get a chance to see your attorney today, unless they are in a jury trial. This is the order in which attorneys will appear. Robert Bauer, Isidro Montoya, James DeWiggins, Tim Molina, Joseph Appelt, Christina Mendiola, Thomas Lane, Kathy Compton, Ed Camara, and Adam LaHood. Is there any attorney's name that I have missed? All right. For the attorneys, it will be very helpful to the court if you would add to your name the name of your client and whether or not it's criminal trial division or family violence. If you cannot do that, that is fine. I will make that happen. When you get sent to a breakout room, think of those breakout rooms as going to a doctor's office. When they send you to the breakout room, you think you're seeing them right away, but you're not. You're waiting there. So put some patience in your pocket. The prosecutors have the ability to move throughout the breakout rooms. If you leave that breakout room, it will show that it is empty and they will move to the next room. Which, Brenna, I may need to stop saying that because when my mom went to the doctor, they sent us to one of the little small rooms. She was in there for less than 5 minutes. No pressure for the prosecutors, but she was in there for less than 5 minutes. Then the doctor appeared. So, all right, Robert Maurer, thank you for changing your name.
Even what do they say? Even the blind pig gets an acorn from time to time.
There you go. Thank you, Robert.
After 2 years, I'll figure it out.
Okay, I'm going to send you to breakout room number 3.
Thank you.
Isidro Montoya, who do you have?
Good morning, Judge. I have Mr. Olivares. He's in custody. He's on the Zoom, and I'm waiting for some. We're going to do a plea today, so I'm waiting for the paperwork.
All right. What is your client's full name?
Mr. Raymond Olivares.
Is it criminal trial division or family violence?
Criminal Trial Division, Judge.
All right. I'm going to send you to breakout room number 4.
Thank you, Your Honor.
And a prosecutor will meet you there. I don't know if they are aware of your agreement or not.
We are, Judge. I'm wrapping it up, so we can put the defendant in there probably. I don't need to talk to him again.
All right, Mr. Olivares, I'm going to send you to breakout room number 4. With your attorney, please go to 4. James DeWiggins, thank you for changing your name. I'm going to send you to breakout room number 5.
Yes, Judge.
Tim Molina.
Morning, Judge.
Yes. Who's your client?
I got a notice for a man named Steven Vasquez for it says status of treatment program, but I don't recognize the name.
All right. We will find out what's going on.
And Judge, I don't know if there's 2, but he's also on the recall docket, Steven Vasquez with Gary Churek as the attorney.
All right. So, no, you're here for Jose Luis Garcia.
Oh, okay, I do recognize that name. I know we've been waiting to see if he's going to get into a DD something.
And Judge, I verified he is pending transfer. Right now, they don't have a date to give me, but he has been medically and legally cleared.
Okay, and that's Jose Luis Garcia?
Yes, ma'am.
All right, Jose Luis Garcia. Let me see where he is. Your client is not on the screen. Do you need to speak with him, Mr. Molina?
I don't, so long as he's on his way.
Yes. So do we have, Rebecca, I think you said we don't have an idea when he will be transferred, but he's been medically cleared?
That's correct. And once they're medically and legally cleared, it's a 6 to 8 weeks. And I'm not sure on the date that he was medically cleared.
All right, Norma, can you put a reset date for Mr. Garcia in 8 weeks, but not put it in the system?
Yes, sir.
And Mr. Molina, if we put it in the system, that would delay his leaving because it will think that he has a date. So this is a date just to make sure he's transferred.
Okay.
And Ms. Ferguson, if you could put that in the chat box for me. All right, on your client, Mr. Molina, it's going to be January 4th.
Okay.
2022. Who would think that we'd be saying that date so soon?
Right.
All right, you're excused. And Norma, you can counsel Mr. Garcia.
Thank you, Judge.
All right, you're welcome. Joseph Appel.
Yes, good morning, Your Honor. Gregory Moton is my client, and I had conferred with Joe Ray at the last setting. If I could just touch base with him briefly, Your Honor.
Okay, I'll send you to breakout room number 6.
Thank you.
You're welcome. Christina Mendiola.
Good morning, Your Honor.
Good morning. Who do you have?
I have Stanley Butler.
Criminal Trial Division or Family Violence?
It's a special unit. It's a failure to register, I believe.
All right, that's Family Violence. I'll send you to breakout room number 7.
Thank you.
You're welcome. Thomas Lane.
Good morning, Judge.
Good morning. I'll send you to breakout room number 8.
And actually, Judge, this was a status setting regarding a subpoena compliance issue.
Yes.
So I don't have much to confer with Mr. Guerra regarding this case yet. We're in the process of subpoenaing the probation file in this case.
Okay, what do you mean you're in the process? Has it been done?
Well, our associate has recently left for the greener pastures of civil law. So I'm taking over a case, and I'm not sure of the status of that subpoena, whether it's been served or not yet.
All right, Norma, on Grace Benton Court. Let's recall this for Monday. Is that possible?
That's fine. I can have that subpoena served this afternoon if she's filled it out. I just have to go check the status of that case.
Okay, well, let's recall it then. Yes, Norma, let's recall it for Monday.
Yes, ma'am.
And may I please confer very briefly with Mr. Lane in a breakout room?
Yes. All right, we're going to recall it for Monday at 9 a.m. November 1st. My birth month. Yay. All right. Another year older coming up upon me. Mr. Lane, where's your client, Grace Benton Court?
I'm not sure. I can reach out to her if she's not logged in.
All right. So this is what I'm going to do, because I realized that her attorney, and I've signed that motion for the attorney to withdraw because she's went to another firm. On November 1st, your client needs to be present. If not, if she's not here at 9 a.m., a warrant may be issued.
Okay.
All right. So I'm going to send you to breakout room number 8, and you can be excused from there.
Thank you, Judge.
Your Honor.
You're welcome. Kathy Compton, thank you for changing your name.
Good morning, Your Honor.
Good morning. I'll send you to breakout room number 9, I think it is. Yes, number 9.
Thank you.
You're welcome. Ed Camara. You're on mute.
Sorry, Judge. I have Aaron Taylor, Criminal Trial Division.
I'm sorry, Aaron who?
Aaron Taylor.
All right, I'll send you to breakout room number 10.
Thank you, Judge.
You're welcome. And everyone, just give me a moment. Adam LaHood.
Good morning, Your Honor. I have
Good morning.
a client with an MTR. It's Family Violence Division.
I'll send you to number 11. Shannon Locke. I'm going to send you to number 12. Where did Shannon go? He disappeared. Ah, he's in 11. Okay, thank you. And Adam. All right, let me do this. Shannon is number 12. And Adam, I'll send you to number 11. All right, Robert Maurer, you're back.
Yes, Judge, can I please go into a breakout room with Mr. Esquivel? He should be logged on as iPhone.
All right, Mr. Esquivel, I'm going to send you to a breakout room with your attorney. You need to show your video.
So sorry.
All right, Mr. Esquivel, you need to always show your video. You
Yes,
understand?
yes, ma'am. Yes, ma'am.
All right, I'm going to send you to breakout room number 3.
Yes, ma'am.
Your attorney will meet you in number 3. Joseph Appel?
Yes, Your Honor. If I could briefly meet with my client, Mr. Moton, just to confirm with him what the offer is, that I'll be back rather shortly, I believe.
All right, Mr. Moton, I'm going to send you to breakout room number 6. And then family violence, Adam LaHood is at number 11 on Paul Ibarra.
Judge, can I see you in a breakout room?
Yes, number 1.
Yes.
Everyone, just give me a moment, please. All right, Richard Langlois, who do you have?
Brandy Lehmann, Your Honor, that was scheduled for PSI on Thursday that you moved to this morning.
Oh, okay.
And she also has one of these PSI violations with the great people down there that violate them for everything.
All right, she has like 4, and I think they're all related to her not following her GPS schedule.
Well, and I understand that, Judge, but I have a problem with that because you get to go somewhere and all of a sudden you're low on fuel and you go to a gas station, gas up, it's a violation. You're hungry, you can't get a hamburger. So that's kind of ridiculous, but those are your wards, not mine.
Well, I mean, here's the thing. She has a felon in possession of a firearm.
Right.
She has a possession with intent to deliver controlled substance penalty group 1, 4,200 grams. She's on bond. She knows what the rules are, and she's not been following them. I mean, all she had to do, if there was someplace she needed to go, all she had to do was ask, and either I would have said yes or I would have said no. A lot of times what I'm discovering is people want to ask for forgiveness instead of permission.
Well, Judge, that may be a good point. On the other hand is, I think, are we here for doing the PSI today and take care of everything, or?
Oh yeah, where's your client?
She's in jail.
All right, then let's bring her on.
Have a few minutes to talk to her.
Yes, as soon as she's brought over, you will have a few minutes to speak with her.
And I have the TAP evaluation here. It's talking about dual diagnosis. Were you able to attend the mental health seminar they had a couple weeks ago?
No.
No. Okay. Well, it was a good one.
Yeah, well, I'm all up on my mental health laws and mental health treatment because as you know, I used to give seminars where I was the speaker on mental health treatment. So I'm up on that.
Well, did you diagnose me?
I could, but do we want to do that on screen? I don't think so.
So get
I'll
somebody.
let Robert Mauer do it.
Judge, my diagnosis of Richard would not involve any psychiatric terms, just lots of bad words.
Guys, it's a Monday. All right, Robert Mauer, what is happening with Mr. Esquivel?
Judge Joe Ray is going to submit a motion to withdraw. It may be with you already, and terminate UNSAT. He was apparently homeless for a while, and that is what led to a lot of these issues. So the states agreed to withdraw and terminate.
All right, Mr. Esquivel, can you unmute? Where are you living now? Do you have a place right now?
Yes, my mom living with my mother as of currently right now.
Why were you not living with your mom before?
Because she didn't have a house herself or apartment. So I was really just going through my struggles by myself, ma'am.
Okay, how old are you?
I'm 23.
All right, what's your level of education? What are you planning on doing with the rest of your life?
I'm planning on getting my GED and taking my basics in college and going for music production, ma'am.
When are you going to take your GED? Everybody always has plans,
Yes, ma'am.
but
Yes, ma'am.
if you're just planning to do something
yes, ma'am.
instead of doing it, that's an issue.
Yes, ma'am. I found a website recently. It takes me $60 to complete every course that I need. And I had got my job Friday, ma'am. And due to paying, legal stuff, I'm gonna try to do it as soon as possible when I get the extra money to do it. But other than that, ma'am, I'm planning on doing it this year, in the new year, 2022.
Well, I mean, let's not do it in the new year because then you're looking at October, November. I'll say October is almost over, but you have November and December. Because here's the thing, people are always planning to do things.
Yes,
and then
ma'am.
you know what ends up happening? They wake
Life
up
happens.
and 2 years later, somebody's still planning on getting their GED.
Yes, ma'am.
So don't let that happen to you. Don't be 32 and somebody's asking you, well, what are your plans? And you're like, well, I'm working on getting my GED.
Yes, ma'am.
You need to set deadlines for yourself, okay?
Yes, ma'am.
All right, let me see if I have that email, Mr. Mauer.
Joe Ray said he signed it this morning.
Okay, I have it here. Joe Ray,
Yes, Judge.
can you check to see if that's been signed? Because I have something that says it's already been deleted.
Yes, there was a mix up. I'm chatting with Rebecca. She sent me another one.
Okay,
Thank you.
you're welcome. Let me see if I have it and I will sign it. Okay, I'm just waiting on that. And as soon as I have it, I will sign it, Robert.
I just sent it to Joe Ray and to you, Judge.
Okay. All right, Joe Ray, did you get it?
Yes, I'm opening it up right now.
Okay. Then we'll take care of that. And then Mr. Opelt, I will come to you. Just give me a moment.
Judge, can you put me in a breakout room with Brandy?
Just one moment. All right, Mr. Esquivel.
Yes, ma'am.
On this case, I'm not the one who placed you on deferred adjudication. So let me just check something so you can know.
Yes, ma'am.
Right, on this case, there was an affirmative finding of family violence. Brenda, can we go on the record for a moment, please?
Yes.
The court is going to call 2016 CR 5975, State of Texas versus Isaiah Anthony Esquivel. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Robert Mauer, Your Honor.
And are you Mr. Esquivel?
Yes, sir. Yes, ma'am.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objections from the defense?
No.
Mr. Esquivel, do you have any objections to us proceeding by video?
No, ma'am.
All right, Mr. Esquivel, the state has filed a motion to withdraw the motion to enter adjudication of guilt and revoke community supervision. The court has signed that. So your probation will be terminated. However, from looking at the plea bargaining agreement, it's not on the docketing sheet, but I'm making assumptions that the previous judge did tell you that there was an affirmative finding of family violence. With an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, is there anything else from either side?
And from the state.
Not from defense, Your Honor.
All right, then, Mr. Esquivel, good luck to you. And as I said, off the record, make sure you make plans and give yourself deadlines, okay?
Yes, ma'am.
All right, thank you. You're excused. Have a great rest of your Monday.
Thank you so much, ma'am. Thank you.
You're welcome. Bye-bye.
Bye.
And everyone, just 1 second, Mr. Pelt. All right, Jacob DeLeon. Your attorney is not going to be able to be here today.
Yes, ma'am.
For medical reasons. So we're going to recall you back on November 30th. If your attorney is able to appear sooner than that, we will call you sooner than that, okay?
Thank you so much.
All right, thank you for your patience. We'll see you back on November 30th.
Thank you so much.
You're welcome. All right.
I'm good. I go ahead and go.
No, just stay
Oh,
there.
okay.
We're going to call a deputy and have them remove you, all right?
Yes, ma'am. Thank you so much.
You're welcome. Richard Langlois, I'm going to send you to breakout room number 3, Brandy Lehmann to breakout room number 3.
Thank you, Judge.
You're welcome. And Joseph Appel?
Yes, Your Honor. I believe that Joe Ray and I have an agreement that we're going to be able to do a plea and knock this out today on Mr. Moton. But I need to get your permission to be excused. So I go pick my daughter up from speech therapy and come back in about 45 minutes or so. That
Yes.
Hopefully give time to get the paperwork drafted and sent to me, et cetera, and be filled out then when I come back.
Okay.
Will that work,
Is
Judge?
yes, is your client in
He is in custody, Your Honor.
correct? All right, what I need you to do before you leave, I need you to go back to breakout room number 6 and have him come back to the main room.
Yes, ma'am.
All right, thank you. All right, Adam LaHood.
Good morning, Your Honor. I have conferred with my client and the ADA, and I believe we're going to have this worked out this morning.
All right, thank you. All right, Brenna, I got your chat.
I'll keep trying it.
No problem. And Mr. Lopez? Just one moment. Let me pull this up. Zachary Lopez. Can you unmute, please? Press the space bar. It's the longest key on the keyboard. All right, Norma, can you get a deputy to help Zachary Lopez unmute, please?
Yes, ma'am.
Thank you.
Oh, yes, ma'am. Can you hear me?
All right, Mr. Lopez.
Hi, good morning, Judge.
Good morning. How are you doing today?
Okay.
All right, Mr. Lopez, they're telling me that you don't qualify for DDRF because they don't have placement for you, which I'm going to work on that and talk to them about why there's not a placement for you. But what we're going to do is we are going to have you considered for the MIC caseload, the mental impairment caseload. So here's my question for you. Do you have a place to live?
Yes, ma'am.
Who will you be staying with?
My dad.
All right, and does your dad want you to stay with him?
He wants to help me, Your Honor. He just wants me to do good. You know what I mean? And he wants me to just start doing things on my own. You know what I mean?
I'm sorry, go ahead, please.
He does want to help me, Your Honor. He just wants me to just stay away from the alcohol. And just, you know, try to do better for myself, but he will help me.
All right, so how are you going to do better? What are your plans on staying away from alcohol?
Getting a job and keeping it, and you know, just staying away from it. You know, that's why I'm here. Just I need to get a job and keep it.
Well, what is your background as far as occupation? Have you worked before?
I've worked at restaurants since I was 16. I've been working at restaurants since I was 16. It's really not hard for me to find a job, but I've been working in restaurants.
How far did you go in school?
I graduated high school.
All right, so I mean, what are you planning on doing with the rest of your life, though? I mean, it's, you know, everybody has different dreams, and I respect everyone's dreams. If your dream is to continue to work in the restaurant, there's nothing wrong with that. As I always tell people, everybody can't be a truck driver. If everybody were a truck driver, there would be other occupations that would be unfilled. Like everyone can't be a heart surgeon. I can't be a heart surgeon. If everyone were a heart surgeon, we wouldn't have brain surgeons. We wouldn't have other things we need. So what is your dream job? I'm trying to figure out, where are you going in your life?
Cosmetology.
Okay, so what are you doing to try to make that happen?
Right now, nothing, Your Honor. I'm in jail, but I do want to do better in life and just, you know, do hair and makeup. That's what I like to do.
Okay, so here's the thing. Anytime you have an occupation that requires you to get a license, there may be issues because you have criminal history. So you may want to, if that's truly what you want to do with the rest of your life, you may want to call them, the people who issue a license, and ask them if your criminal history is going to be a problem. Sometimes it's just an obstacle. It's not for sure, no, you can't get this license because of this criminal history. So you want to check on that before you start spending money, okay?
Yes, ma'am.
So what I'm going to do, Rebecca, I'm going to alter and amend his conditions to include Mick. Do you have access to a phone where you can report to probation by phone?
Yes, ma'am.
And when I say by phone, I mean Zoom.
Yes, ma'am.
We're going to do weekly Zoom reporting until he's accepted in Mick. And we'll do, if you obtain the COVID vaccine, and I'm not requiring anyone to get the COVID vaccine, that's completely your decision. But if you get it, the court will waive 40 hours of your community service restitution.
I got the vaccine already.
Oh, just present it to the court then, to your probation officer. All right, why wasn't he accepted at Cross Point? Do we know? Or lifetime?
I think he left early, Judge, if I'm not mistaken.
Why did you leave Cross Point early?
Your Honor, I left. I went to lifetime recovery, and I left.
Why did you leave early?
Because I was having a real bad use alcohol.
I'm sorry, your voice went down. What did you say?
I left without. Sorry, I left, but I wanted to use alcohol.
All right, so Rebecca, contact felony drug court and see if they can take Mr. Lopez. So I do want him evaluated for the MIC caseload, but I also want him evaluated for felony drug court. And we're going to do 90 AA meetings in 90 days. Is there anything else he needs, Rebecca?
No, ma'am. So do you want felony drug court referral while in custody, or do you want?
Let's do felony drug court while in custody. Mr. Lopez, what this means, because we're getting it in on a Monday, they will have evaluated you before the week is out, okay?
Okay.
So they'll evaluate you this week because we're going to get it in today, and you'll be released by the end of the week.
Okay.
And hopefully they'll accept you, and then we'll do the MIC evaluation out of custody.
It looks like he's already been approved. When they did the DDRF, he was approved. He met qualifications for MIC and DDRS.
Okay, awesome. So we'll place him on the MIC caseload, but let's have him interviewed by felony drug court. And Mr. Lopez, the reason why I'm having you do felony drug court while you're in custody, because I want to make sure you do it. You understand?
What is felony drug court?
Felony drug court is a treatment program. They may suggest that you have outpatient treatment to start off with, and it's to help you with your drug and alcohol problem. Because anytime you're in a treatment facility and you leave the treatment facility early because you want to take alcohol, knowing that you could be going to prison for violating your probation, that's a problem, okay?
Okay.
All right, is there anything else that you need from me to help you do better, Mr. Lopez?
I just want to go to AA meetings, do the felony drug court.
All right.
Myself, but the felony drug, so I don't understand. What is it that I have to do again?
Oh, what's going to end up happening is felony drug court, someone from there is going to interview you. And they're going to let me know whether or not you are accepted in the program. So what will happen is they're going to come interview you. Once they interview you, you'll be released from custody. And then I'll receive a report whether or not you're accepted, okay?
Is an outpatient or inpatient?
It depends on what they think is best for you. If they think outpatient is where they need to start with you, then they'll start with outpatient. If they think inpatient is where they should start with you, then they'll start with inpatient. But here's the thing, you need to be honest and open with them about your alcohol use, because if you're not, they can't help you. So either you want to be helped or you don't want to be helped. You know, it's sort of like if you have, you know, a kidney problem, or if your wrist is hurting or your arm is hurting or your ankle is hurting and you go see the doctor and they say, what's wrong with you? And you say, oh, nothing, I'm fine. They're going to say, okay. You know, and who knows, your ankle may be broken, your leg may be broken, but you're telling them, I'm not in any pain, I'm fine. So you need to be honest with felony drug court so they can know what your issues are, so they can get you the help that you need.
Yes, ma'am.
All right, thank you. I'm going to send you to a breakout room with probation so they can go over conditions with you. I'm going to send you to breakout room number 1 and probation will meet you there.
Thank you, Judge. Have a good day.
Thank you, you too. Shannon Lott,
Morning, Your Honor.
good
I
morning.
have John Maynard today.
Yes.
I've been conferring with Marcus.
Yes.
We filed a motion to set bond for him. We'd asked, talked to Marcus, and he said we could set it at 10,000. I've relayed the offer that Marcus was making to Mr. Maynard, and he would like to try to get him on track before the court considers this motion to revoke.
All right, if I could see you and Mr. Sanders in a breakout room, please.
Yes, ma'am.
Let me see where he is. If I could see you all in breakout room number 2, please. All right, and everyone just give me a moment. Mr. LaHood and Mr. DeWiggins, put some patience in your pocket. I'll be right back. Let me find Shannon Lott.
I think I'm supposed to be in breakout room number 2 with the judge. If I could be.
Hey, Shannon, you're assigned to 2. You just need to click on breakout rooms and join.
Norma, we have an announcement on Mr. Washington's case, but I also wanted to talk to him. So I didn't know if you wanted me to wait and announce to the judge, or if you want to, and then talk to him in a breakout room, or if you want me to do that now.
Do you want me to put you in the breakout room so you can talk to him, or the judge is back?
Okay, I'll just announce to her and then talk to him after, if that's okay.
Mr. DeWiggins.
Yes, ma'am.
Yes, thank you for your patience. David Pettis, what is happening?
Well, he was just restored to competency a couple weeks ago, and the prosecutor over there, Sally Unkefer, has offered us pretrial diversion through the mental health court. We've signed an application to start that process, but I don't really know where it goes from here. Marcus said he spoke to Star Salazar, or did Sally send an email to Star Salazar? Sorry. And we're waiting to hear from her to find out where we go from here.
All right, Norma. So on this PTD, when can we recall it? If you could put it in the chat box, please. All right, we're going to come back on November 30th.
Okay, thank you,
For an
Judge.
update on that. Thank you so much for your patience. Let me see, where is your client?
He's on the screen.
Norma, can you let them know that 14I can go back? All right,
Yes,
Mr. Pettis, thank you so much for coming.
Can I go into a room with him to explain to him?
Sure. I'll send you back to number 5. Mr. Pettis, if you go to 5, please. All right, Norma, I need someone to help him. He made it. All right, Adam LaHood on Paul Ibarra.
Yes, Your Honor.
Yes.
We should have the paperwork signed. I just trying to get my client back in here, and we should be ready to go this morning.
All right, as soon as I have the paperwork on my end, do you know if your client signed it?
Yes, ma'am. We just reviewed and signed it together. It's going to be a revocation.
Okay, well, as soon as he comes back to the room, we'll take that matter up. All right, Kathy Compton.
Good morning, Judge.
Good morning.
So Meredith and I conferred, there are some things that I am going to provide to her, and I may possibly end up needing to file an ex parte motion with the court, but I would just ask for a reset. I'd like to talk to my client though before I leave today.
All right, Norma, on Washington, can I have a 30-day reset, please?
Yes, ma'am. I'll put it in the chat, Judge.
Thank you.
Judge, I was assigned to breakout room number 9. Would you like me to return to that room, or do you want to put me in a different room with him?
All right, just one moment.
Sure.
Compton, I'll send you to a breakout room with your client, but when you finish speaking to your client needs to come back to the main room.
I'll let him know. Thank you.
So if you go back to number 9, and Mr. Washington, if you'll go to breakout room number 9, please. All right, Ed Camara.
Judge, we need a trial date.
All right, has the psych evaluation been completed?
Yes, it has.
All right, are the results back on that?
Yes, they are. He was found competent.
All right, have you received all the discovery?
Yes.
All right, I'm going to send you, who are you conferring with?
Honor.
All right, I'm going to send you and Mr. Morris in a breakout room with the court coordinator, and you will confer over a jury trial date. And when you come back, we will place that information on the record.
Okay,
So I'm
thank
going
you.
to send you to breakout room number 2.
Okay.
And Norma, if you'll go to breakout room number 2, please.
Yes, ma'am.
All right, and the parties on Paul Torres Ibarra. Where are you?
Fine, Judge.
Hi, let me see where Adam is. He's in number 11. All right, when he comes back, we'll take that up. Isidro Montoya.
Hello, Your Honor. I signed the paperwork. My client is in custody. He needs the paperwork sent to the jail. Hasn't been sent yet.
It should be sent once you sign it. So your client is Mr. Olivares.
Yes, Judge.
All right, if you'll go back to breakout room number 4 with him.
Okay, Judge. Thank
the clerks will let you know when they have it.
you.
All right, Adam LaHood, you ready?
Yes, Your Honor.
All right, the court is going to call 2019 CR 0656, State of Texas versus Paul Ibarra. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Adam LaHood for the defendant.
And are you Paul Ibarra?
Yes, I am.
We're proceeding by video because of the pandemic. Any objections from the state?
None from the state, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Ibarra, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am. Yes, Your Honor.
We'll find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. And also First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them? And did you understand them? Sorry.
Yes, Your Honor.
Are you the same Paul Ibarra who was placed on deferred adjudication in 2019 CR 0656 for the offense of endangering a child, risk of bodily injury on April 18, 2019 for a period of 3 years? Is that you?
Yes, Your Honor.
Date?
Your Honor, we have an agreement in this case. Defendant's going to plead true to the last 2 violations on the amended MTR.
Right. And do you have that motion to read those 2 allegations?
Yes.
You may
Violate.
proceed.
Sorry.
That's okay. You may proceed.
Violated condition number 1, on or about the 7th day of September 2021 in Bexar County, Texas. The defendant, Paul Luis Ibarra, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that, true or not true?
True.
State?
Violated condition number 5, in Bexar County, Texas. The defendant, Paul Luis Ibarra, did then and there fail to report to the supervision officer as directed for the months of March, April, May, June, July, August, September, October, November, December 2020, in January, February, March, April, May, June, July, August 2021 in violation of condition number 5.
How do you plead to that, true or not true?
True.
State?
We're waiving the other violations. The agreement is to
Just one
enter.
moment. Any objections to the state's waivers?
No, Your Honor, no objections.
Mr. Ibarra, did you understand by pleading true to violations of conditions 1 and 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 5?
Yes, Your Honor.
The first one is.
Court will find violations of conditions 1 and 5 true. Is there an agreement?
Yes, Your Honor.
What is your agreement?
To enter an adjudication of guilt and revoke the defendant's community supervision, an agreement for 180 days in a state jail facility. The defendant will also plead to the evading arrest case. We will TIC the failure to ID case, and I will send that dismissal shortly. And we would also ask for credit for time served under this case, or credit for time that he's already served under this case.
All right, what is the case number that you are taking in consideration?
Pull that up real quick. $669-106. It's in County Court 15.
And are you all proceeding with this plea before he pleads to the evading arrest?
I'm fine with proceeding today.
All right. Defense, is that the agreement?
It is, Your Honor. We ask the court to please honor and follow that agreement.
Mr. Ibarra, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
Then the court will follow your agreement. The court will grant the motion, find you guilty, not grant you community supervision, sentence you to 180 days in the state jail facility, give you credit for any time served, take in consideration 669-106. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Nothing from the state.
Mr. Ibarra, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, if there's nothing else, we'll close the record. Mr. Ibarra, how old are you?
28.
All right, you're 28 years old. You now have a felony conviction if you didn't have one before, so you just made your life more difficult. Hopefully you have learned something while you have been on probation. You understand?
Yes, Your Honor.
All right, good luck to you, Mr. Ibarra. Norma, you can let them know that 16F can go back.
Yes, ma'am.
Okay, I'm on it right now.
Thank you, Your Honor. May I be excused?
Yes.
Thank you.
Everyone, just give me a moment. All right, Shannon Locke.
Good morning, Your Honor. I have Jonathan Maynard, and it will be a contested hearing. If we could set a contested hearing.
All right.
And we're
Let me
requesting
find your
a
clients. All right, is Marcus Sanders available?
Yes, Judge.
Okay. All right, and Brenna, we are not on the record. So on Mr. Maynard, is there an agreement on a bond?
on the bond, Your Honor.
And what is that agreement?
Or 10,000.
Any other conditions?
We didn't discuss them, Judge. We would ask for GPS tracking, but it wasn't agreed to.
All right, Mr. Locke?
If we could waive the fees on that, Your Honor.
Yes. All right, to the clerks, could I have a B page, please, on 2013 CR 9188? And Norma, if I could have a date for a contested motion to revoke hearing on Mr. Maynard, please.
Yes, ma'am.
Thank you. All right, so November 29th will be set for a contested hearing. And Norma, is that at 2?
All right, Judge, I was muted. Yes, ma'am.
All right, and so that will be at 2 p.m. If Mr. Locke, if it becomes not a contested matter, then just let the court know and we'll take it up in the morning.
Thank you, Your Honor.
You're welcome. So I'm signing the agreed order now.
Maybe excuse
If
Your Honor.
there's nothing else, you are excused. Norma, can you
Thank you
let
so
them
much.
know that you're welcome. Let them know that 16G can go back.
Yes, ma'am.
All right, Richard Langlois.
Yes, Your Honor.
Yes, are you ready to proceed?
We are, Judge.
Okay. All right, who are the parties on Brandy Lehmann?
I can do it, Judge, but before we do that, can I go into a breakout room with Richard really quick? I've got a question for him that I would like answered before we do this hearing.
Yes, Richard, if you could go to breakout room number 2, please.
Sure.
And Norma, do we have a reset date on Ed Kamara and his client?
Yes, ma'am. We're going to come back on the 22nd, Judge.
22nd of what?
Of November.
All right, but is it not a jury trial?
No. They're going to try to talk to the complainant first, Judge.
Okay.
There's Hunter. He just came up.
All right,
Yes,
thank
Judge.
you. Okay, so on Taylor, November 22nd. Okay. All right, James Oldestor.
Yes, ma'am. I just came in. Terrence Scott, MTR, probably need to, he was out with COVID a month ago, got reset to today. So probably need to talk to the DA and probation and because we didn't get
Right.
anything. So,
That's family violence. I'm going to send you to breakout room number 3.
thank you.
You're welcome. Rebecca,
Yes, ma'am.
on Armendariz, Norman said he's already been transferred to Guadalupe County. So I guess they're doing everything in Guadalupe County now?
We had heard, on October 12th, he was in our court and you went ahead and allowed the transfer to Guadalupe County and for him to do the felony drug court over there.
All right.
You looked it up and verified that they had a felony drug court.
All right, thank you.
Yes, ma'am.
All right, Richard Langlois, you ready on Miss Lehmann?
Yeah, Judge.
All right, and that's with Meredith?
Yes,
That'll be with me this morning, Judge.
Meredith.
All right, the court is calling 2021 CR 2969 and 2021 CR 2972, State of Texas versus Brandy Lehmann. Can I have parties announced for the record, please, for the state?
Meredith McIntyre for the state.
For the defense?
Richard Langlois for Brandy Lehmann, Your Honor.
And are you Miss Lehmann?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
None, Your Honor.
Ms. Lehmann, do you have any objections with us with this hearing taking place by video?
No, ma'am.
All right, in cause number 2021 CR 2972, you're charged with felon in possession of a firearm. According to the plea bargain agreement, the state opposes your application for community supervision or deferred adjudication. Punishment is to be assessed at a cap of 5 years in the prison. The state is taking in consideration 2021 CR 3211, 2020 CR 3212, 2021 CR 2970, 2021 CR 2971, and this is to rank concur with 2021 CR 2969. And cause number 2021 CR 2969, according to the plea bargain agreement, the state is opposed to your application for community supervision or deferred adjudication. There should be a cap of 5 years, and they're taking the previous cases mentioned in consideration. And cause number 2021 CR 2969, the state waived count 1 and the repeater paragraph without objection from the defense, and you pled to count 2, possession of controlled substance, penalty group 1, 4 to 200 grams. Have both parties had a chance to review the PSI report? State?
Yes, Judge.
Defense?
I have, Judge, but I will note for the record that her mental health evaluation is set for November 9th. And it's not been completed, but there's quite a bit of information in there that we can use that, and I'll provide you some other information as to her mental development.
So are you asking for a continuance, Mr. Langlois?
I am not asking for a continuance.
All right.
I think we have enough information to address it, and what I can provide you will fill in what will probably have been provided to you by the mental health evaluation.
All right, off the record for a moment. Mr. Appelt, I'm going to send you to breakout room number 10.
Judge, I'm having an issue with the documents that are being sent to me by email. If I could get it sent to a different email address, for some reason, my computer is flagging it as spam and it won't let me get into the documents at all.
All right, so what I'm going to do, I'm going to send you and your client to breakout room number 10. Who was the prosecutor you were conferring with?
Joe Ray.
All right, so Joe Ray is in number 3. As soon as Joe Ray leaves number 3, I'll send him to breakout room number 10 as well.
Very well, Judge. Thank you. And I've sent a chat to Ms. Ferguson regarding what the court sends me to fill out too.
All right, thank you.
Thank you.
Sure. All right, we're back on the record. Any objections to the PSI report, State?
No, Your Honor.
Defense, any objection to the PSI report?
No, Judge.
All right, State, you're opposed to the application. You may proceed.
Okay, Your Honor, we'll keep this kind of brief because most of the reasoning behind our offer and our position is based on her criminal history and her repeated failures at felony probation. As Your Honor can see, just as recently as 2017, she was revoked on a felony drug charge and given 3 years. So she would not have been out for much more than a couple months before picking up all these new charges, most of which the ones part of the plea deal that we agreed to take into consideration have already been closed. We also waived her repeat offender paragraph. So she got a pretty good deal on this, considering all that's going on. I just don't believe that she's a good candidate for community supervision based on her criminal history, as well as just as recently as the last, I believe, month, she's picked up a number of violations while out on bond, which again shows us that we don't know that probation is going to work again. It has not worked in the past. I don't know that it'll work again either. But if Your Honor feels like giving this defendant another chance, we would definitely ask for inpatient. We think her drug issues are significant enough that she would need inpatient. But for all the reasons we said, we just don't feel like community supervision is appropriate for her and would ask Your Honor to deny her applications.
All right, defense?
Judge, regarding the violations during her pretrial, she didn't have a car. So a lot of these violations done because she had to use Uber and things like that. Ms. Lehmann is a 43-year-old female. At the age of 12, a 30-year-old cousin decided to molest her and over repeated number of times. There was no outcry on this. And the reason they had was, well, she dressed nice. The boyfriend or the cousin thought she dressed nice, so he decided to have sex with her. And then in high school, she had a boyfriend that was older than her, about 4 or 5 years older. And she got pregnant. And he became an alcoholic. He became physically abusive to her. And he ended up committing suicide. And she dropped out of about the 10th grade. Thereafter, she's had other boyfriends who beat her up, physically abused her. She never called the cops. Obviously, she has a low self-esteem. Obviously, she's always had this situation is that, her sexual abuse was her fault. And when that happens, as you know, in your mental health, education, people don't, they go to drugs to erase the pain. And Brandy's done this. And she's not been able to stop, but she's this year in this situation she's in. She's 43 years old. She has a daughter that's going to have a child. She has a 25-year-old son. She's reunited with her family, and she wants help. And my position's always been, if somebody needs help, give it to them. And I think they can probably, if they do well, that's for their benefit. If they don't, then they go to prison. At least she gets the opportunity to do it. But in this case, I think there's a dual diagnosis for drug addiction and mental health treatment. And that's what I'm asking this court to do. I know you have the Safe B special needs. We have the SATF, I think, that also has special needs. There's MyOp, or one of those programs, if they're willing to do that. And, my wife happens to be the mental health joint commissioner in Texas. So we have a lot of talks about that. And one of the problems about mental health is this. They don't have enough people to help all these people. They don't have enough facilities or beds, stuff like that to put them in. And we have to use what we have. And I think it's very important that we do treat people with mental health to get them back on their feet. That's the only reason I'm asking this court to, overlook, or not overlook, but look at the differences that this person is begging for help at this time.
All right, State.
Your Honor, I mean, I just would reiterate our argument that she was given a pretty good offer considering all the charges facing her in this case. And it'd be one thing if her last felony probation was a long time ago and there's been a huge change, but it was not that long ago and she was unsuccessful. And so that's why we ask that Your Honor deny their application.
All right, Ms. Lehmann, is there anything you wish to say to the court?
Yeah, Judge. May I respond just briefly?
Yes.
I understand Meredith's argument, and it's well stated in every respect. On the other hand, when a person has been physically abused and sexually molested, those people don't go to jail. But the person who was physically abused and molested in prison. That's my point in this case. I'll let Ms. Lehmann address you, Your Honor.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Mr. Langlois, would you like to ask questions?
Ms. Lehmann, tell the judge where you want to be in the next several years. You're 43 years old. You've been in trouble. You've been to prison. Okay. I think you had a pregnancy where you've had a miscarriage recently. Is that correct?
Yes, sir.
Okay. What is your goal in life at this point?
Since I've been on the monitor, it's been a blessing, really. I know I have some violations, but they were going to the emergency room twice. And one was just coming home late from the laundromat. So for me not to be in trouble this whole year and to stay at home, that's something that is an accomplishment, I guess. I really am trying hard to do the right thing. I really want to do the right thing. My daughter's about to have a baby and I got them back in my life this year. And I really want to be able to be there for them and start my own business. So I have, I'm proud of that. I have my own apartment. My lease isn't over until April. So there's some things that I've done this year while I've been on this monitor that I'm really proud of. And, I really kind of thank the courts for putting me on the monitor because it forced its hand on me and I feel like I'm going in the right direction. I know I've made a lot of mistakes in the past, but I really feel like I'm going in the right direction right now. I really want an opportunity to show that I can be successful.
All right, any questions from the state?
No, Your Honor, the state's not going to have any questions.
All right, Ms. Lehmann, when's the last time you used drugs?
Probably about 8 days ago.
And what were you using?
Opiates.
All right, and your trips that you were taking that were not approved, where were you going?
I went to the ER.
Were you using drugs then?
No, I went to the ER twice.
Okay.
I got COVID last month, so that was one of the trips. And the other trip is when I miscarried my baby. And I think one of them was coming back from the laundromat late, like 30 minutes late.
All right, and state, if the court were to deny the defendant's application, what amount of time would you be asking for?
Your Honor, we capped it at the 5 years. And so at this point, we're okay with the lower end of that spectrum, given all of her issues and the fact that losing a baby is probably one of the biggest punishments she could receive.
All right. So this is where we are, Ms. Lehmann, and it's up to you to make choices. I always tell people life is filled with choices. Your criminal history, I always tell people criminal histories, and I would tell my clients this, criminal histories are like your credit report, but it's a credit report for crime, right?
Right.
And so people look at that, and when they look at that, sometimes they see you and they see you in a certain light because they're looking at your criminal credit score. And your criminal credit score is not good. It shows that you've been given chance at probation. Did you learn anything in 2010? Because you were placed on probation. You received an MTR and they denied it. And then they terminated you unsatisfactorily, which I think as defense attorneys, a former defense attorney, Mr. Langlois and myself, and probably the ADA Meredith McIntyre know what that terminated unsatisfactorily mean. It's sort of like people saying, well, she was on probation. She did something. We really don't want her to go to jail, but she didn't do a good job. So did you learn anything from that?
Yes.
What did you learn?
To take this more seriously. I think that was one of the first times I've been in the court system.
All right, then we have a deadly conduct from July 2010. Yes. You were sentenced to 5 months. Did you learn anything from that?
Yes.
What did you learn?
That was during a time when my ex-husband and I were separating from each other. There was a lot of back.
What did you learn? Like, I'm not asking you the circumstances behind the offense. I'm asking, what did you learn? Because I can tell you what I know. People who are in the midst of their drug addiction, they tell some great stories. I know this because I've been in all the treatment courts as an attorney. And their stories are great. They sound very believable. They can tell you, I met the tooth fairy. This is what she said to me. And the story is so believable. They'll have you thinking, wait a minute. Is there a tooth fairy? They can say, I met Tinkerbell. She talked to me. And you'll start thinking, wait a minute. Maybe there is Tinkerbell and I just haven't met her. Maybe she won't speak to me. So I'm not asking you the facts behind these stories. I'm asking, what did you learn? Did you learn anything? If you didn't, that's okay. Because what I'm going at, it appears that you're not learning anything. You're just picking up cases. You're being given jail time. You do your time, you get out and you pick up more cases. So your life is riddled with criminal histories. A lot of it is drug cases. I mean, the state was right. 2015, you were given probation. And you were sent to SATA. And then you end up getting revoked. And you got revoked because this number one means you have a new offense. So you picked up a new crime. Number fives are the not reporting. So you did that. And I believe, Rebecca, what are the number twos?
Drug use.
Drug use. And then all of these cases, these are cases that that the state is asking to be taken in consideration.
I've never gone to a rehab or anything like that before.
No, up here it says that you were sent to SATA.
No, they denied my application at SATA.
And why did they deny that?
Because of my mental health issues.
Okay. So here's where we are, Ms. Lehmann. I understand what your attorney is saying. I understand what your issues are. I'm going to give you a choice. Life is filled with choices. Sometimes we make a choice and we regret that that's the choice we made. But here's your choice. I can sentence you to 3 years in prison on each of these cases. They were run concurrent. or either I can give you 8 years of deferred adjudication on each of these cases. And if I give you deferred adjudications on each of these cases, if you are unsuccessful in 2021 CR 2969, I could sentence you up to 20 years in prison.
Okay.
And if you are unsuccessful in 2021 CR 2972, I can sentence you up to 10 years in prison. So you can accept 3 years on each of these cases. But if you want deferred adjudication, you're going to safety. So you're going to remain in custody until you transfer it to safety. And then after you get out of safety, you're going into felony drug court. So those are your choices.
I did want to go to drug court.
Well, no, your choices are you get the 3 years, or either you're going to safety. After you get out of safety, you will be in felony drug court. Those are your only choices. 3 years, or either way, you're going to remain in custody. So you can do 3 years prison, or either you can go into inpatient treatment. But you are not coming out of that Bexar County jail. You are going directly into inpatient treatment, or either directly to prison to serve your sentence. Which would you like to do?
Take the 3 years.
All right. So see, Richard, she doesn't want treatment. All right. In 2021 CR 2969, the court will find you guilty. The court will sentence you to 3 years in prison, give you credit for any time served. This will run concurrent with 2021 CR 2972. Take in consideration 2021 CR 3212, 2021 CR 3211, 2021 CR 2970, and 2021 CR 2971. Is there restitution in this case for drug testing?
As judge, I believe there would be for the drug testing. I don't know the exact amount. I can try to pull that up.
Oh, it's $177. At least that's what I have in my in the PSI report. So restitution of $177 for drug testing. And cause number 2021 CR 2972, court will find you guilty, sentence you to 3 years in the prison, give you credit for any time served, this will run concurrent with 2021 CR 2969. Take in consideration 2021 CR 3211, 3212, 2970, 2971. Is there anything else from either side with regards to sentencing? State?
No, Your Honor.
Defense?
No, Your Honor.
Ms. Lehmann, in each of these cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those documents with your attorney? Did you understand it? And did you electronically sign it?
Yes.
Because in each of these agreements, they're plea bargain agreements, because I followed your plea bargain agreement because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because in each of these cause numbers, these are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, if there's nothing else, we'll go off the record. Ms. Lehmann, how old are you?
43.
All right, you're 43 years old. You're getting to the point where more of your life is going to be behind you than in front of you. I know you mentioned your granddaughter and you want to be there for her. You can't be there for her because you're in the throes of your addiction. You would not be a good role model. You would not be a good babysitter. And I'm not trying to be mean to you, but these are just facts. You would not be a good role model for a child. And until you get your life together, you should not be in any child's life. You shouldn't be in your daughter's life. You shouldn't be in your grandchild's life because you're just living your life. You're living your life recklessly. I always tell people, once you start being dishonest, my mom tells me never to use this word, so I hope my mom will forgive me. I'm going to use it. And that word is lie. Once you lie to yourself, then you're really in a big problem, right? You can lie to other people. You can lie to your attorney, say, I want treatment. Give me treatment. You can tell the state, give me treatment. And that could be a complete lie. But if you lie to yourself, you are in a sad, sad situation. Now, do I think you need drug treatment? Most definitely. Should it be inpatient treatment? Most definitely. Is something going to end up happening if you continue on the path you're on? Most definitely. Because people who make drugs, they're not chemists, they're not physicists, they don't care about their customers. They're just cooking things up in the laboratory, which is usually their garage, roaches and rats running around. You don't know what's in the drugs that they're making. Maybe you may end up taking it. Maybe you may end up being fine. You may end up overdosing. But do not bring your addiction to your daughter's and your granddaughter's doorstep. They do not need that. You understand?
Yes, ma'am.
All right. And know that you had your chance. And I wrote in the docketing sheet that I gave you a chance at deferred adjudication in treatment, and you decided no, you wanted to go to prison. So if you report another judge, don't tell that story, okay? Good luck to you, Ms. Lehmann. Norma, you can let them know 12 can go back.
Yes, ma'am.
Thank you, Mr. Langlois.
Thank you, Judge.
You're welcome.
Judge Jim Ultersdorf, I've been conferring with the DA, Joe Ray, and Mr. Scott, my client. Mr. Scott is deciding what he should do on his MTR. And I'd like to go and come back in a few minutes and tell him in 13 that I'm over here with you. And
Yes.
you have priority, okay? I'll be right back.
All right, sure, no problem. Who is on Raymond Olivares?
It's me again, Judge.
Mr. Montoya, Judge.
All right. All right, the court is going to call 2021 CR 8639, State of Texas versus Raymond Olivares. Can I have parties announced for the record for the state?
Meredith McIntyre for the state.
For the defense?
Isidro Montoya, Your Honor, for Mr. Olivares.
All right, and are you Mr. Olivares? Could you unmute, please? Just press the space bar. It's the longest key on the keyboard. Are you Mr. Olivares?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Olivares, I'm going to show you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Olivares, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state waives the enhancement paragraph.
Any objections?
No objection.
All right, Mr. Olivares, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
All right, what you're charged with is prostitution 3 or more priors. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be, oh, I'm sorry, just 1 second. I'm multitasking here. And my computer is flashing different. All right. Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with witnesses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, he is.
Mr. Olivares, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
The court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility.
Yes, sir.
There's a $1,000 fine and there are no applications. Did you understand that to be the agreement?
Yes, ma'am.
They didn't call me.
Counsel, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then, Mr. Olivares, to the offense is charged in indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all attachments.
Any objections?
No objections, Your Honor.
Mr. Olivares, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
There's one on the base that I saw.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I follow the recommendation of the ADA, Your Honor.
All right, the court then will, as previously stated, finding you guilty, the court will sentence you to 6 months in the state jail facility, give you credit for any time served. There's a $1,000 fine, time and money will run concurrent. Is there anything else with regards to sentencing?
Your Honor.
Mr. Olivares, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we'll close the record. Mr. Olivares, how old are you?
I'm 64 years old.
All right, here's the speech, Mr. Olivares. I am in the same boat that you're in.
Yes, ma'am.
I personally don't believe I'm going to live to be 120. I don't even know if I want to live to be 120. But I have more of my life behind me than in front of me, right?
Yes, ma'am.
So you definitely have more of your life behind you in front of you, unless you're planning on living to be 120.
Yes, ma'am.
I looked at your criminal history because it was included in the plea bargain agreement. And it seems that you've been in and out of jails and in and out of prisons. What are you planning on doing with your life?
Well, I'm getting older now. I'm trying to stay out of trouble and do what's best in my life.
All right, well, you can't be picking people up, and I don't mean any disrespect, but you know, people who are procuring services, they're usually not the most attractive people.
Yes,
They
ma'am.
usually haven't taken baths. I mean, who wants to be doing that, right?
Yes, ma'am.
And then to top it off, you don't even know if they're going to kill you or not. You may
Yes,
have been
ma'am.
lucky that the car that you was getting in was an undercover police officer, as opposed to some guy or some girl who is a serial killer or who knows what. Because each time you get into the car with a strange person, you're taking your life in your own hands. You understand?
Yes, ma'am.
All right. I hope you're going to change your ways. Good luck to you, Mr. Olivares.
Yes, ma'am.
All right. Norma, 14A can go back. Mr.
Thank you, Judge.
Montoya.
Yes, ma'am.
All right, James Oakestorff, what is happening with your client?
I probably should, I've returned. I'll probably rejoin Mr. Scott and see if he's made a decision with regard to the options on his
All
MT.
right. Mr. Scott is in number 3. I'll send you to breakout room number 3.
Thank you.
And Mr. Montoya, if you don't have anything else with us, you are excused.
Thank you, Your Honor.
You're welcome. And Mr. Pelt, is all your paperwork signed?
I believe it is, Your Honor. If they could just be double checked, please. And then
All
we'll
right,
be
what
ready
I'll
to
do
go.
is I'm going to send you and your client to breakout room number 2.
Okay. We just came from 10 where he went through it all, so it should be turned in.
When you say who is the person who went through it all?
Myself and Mr. Moton.
Oh, no. You need a clerk because he needs to be sworn in.
Ah, there you go.
There you go. So I'm going to send you to breakout room number 2, and a clerk will meet you in breakout room number 2 to swear your client in. And Rebecca, do you have an update on Gary Churick's? Oh, it's discovery compliance. Let me see. All right, Mr. Churick, is your case family violence or criminal trial division?
Criminal trial, I believe, yes.
All right, I'm going to send you to breakout room number 4.
Okay.
You're welcome.
Judge, can I see in a breakout room? It's Rebecca.
Miss Lawson, I need you to come to breakout room number 8, please.
Okay, I've got him on the screen. We're still talking over here. Okay, don't have an answer yet. I'm in court with him. Okay, I'm still talking to him. We're still in court. Okay. This is Jim Oltersdorf speaking. Can I go? Oh, hi.
What's going on?
Could I go into a breakout room with the District Attorney Joe Ray?
Yeah, that's me. I'll put us in a different room.
Oh, should I press breakout room here?
Is your client still in there?
He's in his breakout room.
I'll send us to another one. You'll get an invite.
Okay.
All right, Gary Chirek, Stephen Vasquez, what's happening with discovery?
Yes, ma'am. We're just gonna need a trial setting. We've
Well,
got,
no, we're here for discovery. Do you have all your discovery?
yes, I have all the discovery in the case.
All right, State, have you tendered an offer?
Yes, Judge.
Ms. Ferguson, on Stephen Vasquez, can I have a 2-week reset, please?
Yes, ma'am.
And I'll check the chat. All right, Mr. Vasquez, your plea deadline date in this case is going to be November 15th. So at that time, you need to let the court know whether you are accepting or rejecting the offer. Do you understand?
Completely, Your Honor.
All right, so we'll see you back on November 15th.
Okay, thank you so much.
You're welcome.
Yes, sir. Yes, sir?
Yeah,
Okay, we'll be excused?
yeah.
Yes.
Okay,
Norma,
thank you,
can
Your
you
Honor.
let them know 14G can go back? Have a great rest of your day, Mr. Vasquez.
Yes, ma'am.
All right, thank you, Mr. Chirac.
Thank you, Judge.
All right, can someone tell me what is happening with Stanley Butler?
Judge, we have an agreement on that case. He was actually sentenced out of county, so I was trying to track down the case number so we could put that in the agreement, and he could get credit for that. But we have all that information now. I think defense is ready.
All right, if it's going to be a plea of true, then there needs to be paperwork done. Ms. Ferguson, is this going to be for time or no?
It is.
All right, Ms. Ferguson, I'll need an acknowledgement.
Judge, that's paperwork has been sent. It's in her email. It's in Christina's email. I chatted her to go to the breakout room number 7 with her client.
All right, Ms.
We've signed them both. My client and I have. So it should already been returned.
Okay, we will see if we have it. All right, and let's bring, is Mr. Butler, if you could go back to that breakout room and bring your client out, we will take that matter up. All right, Mr. Butler. Right now, I go to the breakout room and crazy things happen. I'm just gonna have to stop going to breakout rooms. All righty. So on Mr. Butler, if you could unmute for me, please. Court is calling 2015 CR 7919, State of Texas versus Stanley Butler. Can I have all of the parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Christina Mendiola for the defense, Your Honor.
And are you Mr. Butler?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Your Honor.
Any objections from the defense?
No, we have no objection, Your Honor.
Right. Mr. Butler, did you review a document with your attorney entitled Defendant's Consent to Appear by Video Conference? Did you understand it and did you sign it?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily consented to appear by video conference. Next, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? And did you understand it?
Yes, ma'am.
Are you the same Stanley Butler who was placed on deferred adjudication in 2015 CR 7919
Yes,
for the
ma'am.
offense of sexual assault of a child on June 1st, 2016 for a period of 5 years? Is that you?
Yes, ma'am.
State?
Your Honor, we have an agreement in this case. Defendant's going to plead true to violation of condition number 1, and we're going to waive the other violations.
All right, would you like to read that condition, please?
Violated condition number 1, on or about the 21st day of December 2019 in Brown County, Texas, the defendant Stanley Butler committed the offense of assault in violation of condition number 1.
How do you plead to that, true or not true?
That's not true. It wasn't in Brown County. It was in Mason.
Yeah, sorry, Your Honor, that is, the MTR says Brown County, but it's actually Mason County. So.
All right, is there a motion?
Yes, Your Honor, we would ask to amend the MTR to Mason County instead of Brown County.
Any objection to the amendment?
No objection.
All right, Mr. Butler, do you understand that the state changing the location of the offense from Brown County to Mason County is a substantive change? Do you understand that?
Yes, ma'am.
Do you still wish to proceed with
Yes,
that
ma'am.
change?
Yes, ma'am.
Do you understand that the court would give your counsel a continuance if requested because of the change of the county from Brown to Mason County?
Yes,
Do you
ma'am.
understand? Do you still wish to proceed with this motion knowing that?
Yes, ma'am.
Right. Then State, would you read the corrected allegation, please?
Violated condition number 1, on or about the 21st day of December 2019 in Mason County, Texas, the defendant Stanley T. Butler committed the offense of assault in violation of condition number 1.
How do you plead to that, true or not true?
Guilty.
No, true or not true?
It's true.
Right, State?
Your Honor, the agreement is to
State,
enter
are you
an-
waiving the allegations?
Sorry, yes, we're waiving the other allegations in this motion.
Any objections to the state's waivers?
We have no objection, Your Honor.
Mr. Butler, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
The court will find violation of condition number 1 true to all the inmates at the Bexar County Jail. Those masks do not work if your nose and your mouth is not covered. You're doing that not for yourself, but for other people around you. All right, the court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor.
What is the agreement?
The agreement is to enter an adjudication of guilt, revoke the defendant's community supervision, and sentence him to 3 years in the Texas Department of Corrections. That case, we would ask to run concurrent, and we'd ask that he be given credit for time served under his case in Mason County. That case number is 204837. He was sentenced in the 452nd Judicial District Court to TDC in that case.
That is the agreement. We ask that he be given credit for all the time that he has served in this case.
All right, so all the time that he served in this case, are you saying that's a judgment satisfied, State, or no?
No, it's for TDC time. We're just asking that he be given credit for that case.
That is correct.
All right, so you want him to receive credit for all the time that he served on this case and also time from the Mason County case?
Yes, he was sentenced on October 16th, 2020 in that case.
All right, Mr. Butler, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
On the firearm case, my mom said it 30 times.
All right. The court will find you guilty. The court will follow your agreement, sentence you to 3 years in the prison, give you credit for any time served. This will run concurrent with 2048371, a case out of Mason County. Give you credit for any time served in 2048371. The court has been told that that time begins from October 16, 2020. There's also Chapter 62 registration. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it? Mr. Butler, did you
Yes,
review
ma'am.
that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. You understand?
Yes, ma'am.
All right, we can go off the record. Mr. Butler, good luck to you. You've got to start doing right. Know better, do better. You understand?
I can tell you ain't ever gonna see me in this situation again.
Okay. All right. Good luck to you. Norma, L6 can go back.
Thank you, Your Honor.
Yes, ma'am.
Ed Bartholomew, we recalled your case for tomorrow at your request.
Lad, L6 can go back. Mr. Butler.
You're on mute, Mr. Bartholomew.
Thank you, Your Honor. I just wanted to check in. We just finished.
All right, it's done. Thank you.
Here's a nice bench here, though, Judge. Congratulations, by the way. You got your wish.
Well, I didn't wish. I knew it was going to happen. I say don't waste wishes on LSU beating Florida. I mean, it's going to happen.
It was the coach I was referring to, Your Honor.
Well, you know what, though? Here's the problem with the coach. They're talking about Jimbo Fisher. We don't want to do that. So we shall see how it goes.
Who do we
No
want?
insult
Judge?
to the fans of Jimbo Fisher, but we just do not want him at LSU.
Well, who do we want, Judge?
You know what? There are many people out there that we would like, but they're coaching in the professional division. So we shall see.
You don't want Urban Meyer either, Judge.
No, we do not. If you talk to Cornelius, that's what he always says. So we shall see how things go. Can we just have
Maybe you can
someone
get
who
Bruce
can
Saban
run
to
an
come on back.
offense?
Hey, Judge, maybe you can
Yes.
get Mr. Saban to come back.
No, that there are hurt feelings there. I think in order for us to have him back, people need therapy because we need to address the hurt feelings and the betrayal. It's hard to
I
come
thought
back
the
from
most interesting-
betrayal.
Judge, the most interesting comment was, we just need somebody that can restore faith and camaraderie at LSU once again. We don't need to worry about winning, just somebody could restore faith in the program.
Okay. All right, Ed, have a good one.
Thank you, Judge. Bye-bye.
Bye-bye. All right.
See you
who's-
tomorrow, Your Honor. Thank you.
Thank you. Who's the prosecutor on Gregory Moton?
Should be Joe Ray, Judge.
All right. Joe Ray is not here. Is there anyone who can stand in for Joe Ray? And I'll walk you through the plea.
Madam
Yeah,
Morris,
Judge.
Judge.
Thank you. All right, the court is calling 2020 CR 9415, State of Texas versus Gregory Moton. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Joseph Appelt for the defense.
All right, are you Gregory Moton?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
And from the state.
Any objection from the defense?
No, Your Honor.
Mr. Moton, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor. I've received the discovery and I've discussed it with my client, Mr. Moton.
Right, the court will find that the state is in compliance with discovery. Mr. Moton, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor. I believe the state will be making a motion which we will not object to waive the enhancement paragraph.
That is correct. Any state, it appears that you're waiving the enhancement paragraph,
That is correct, Your Honor.
and that's without objection, defense?
No objection, Your Honor.
All right, Mr. Moton, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with violation of sex offender registration? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Moton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain agreement. Did you review that with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is waiving the enhancement paragraph. Your punishment is to be assessed at 2 years in the prison. There's a $1,500 fine. There are no applications in Chapter 62 compliance. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
State, is that the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there have not.
Then Mr. Moton, to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 and its attachments into evidence.
Any objections?
No objections, Your Honor.
Mr. Moton, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to a jury trial, the right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor. If it pleases the court, we would waive a PSI.
All right, anything you wish to say on behalf of your client?
Mr. Moton, although he did not register, he does realize that he needs to register. He was actually gainfully employed during this period of time, and he was at a constant residence at with his then significant other. we ask you to follow the plea bargain, Your Honor, which is the 2 years to do, and give him
All
credit
right.
for time served and time and money to run concurrently.
All right, the court will sentence you to 2 years in prison, $1,500 fine. Chapter 62 registration, time and money is to run concurrent, give you credit for any time served. And as previously stated, the court is finding you guilty. Mr. Moton, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record, Mr. Moton. Sometimes people want to leave their past behind, but your offense is not a past that you can leave behind. You always have to register. If you don't register, you're going to come back and you're going to find yourself going back to the prison. How old are you?
48.
You're getting to that time in life where you have more of your life behind you than in front of you. So you know you have to register, whether you think it's fair or not, whether you think you're done your time and you're done with it. Doesn't matter. You have to register. People want to know where you are. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Moton. Norma 14B can go back. Okay, Brenna. I know I sent you that meme where the court reporter does not want to push through. We have 2 more cases. One is, and there are motions to revoke. Amanda Lawson with Joseph Appelt.
Okay.
And Terrence Scott with James Olterstor.
Okay, I'm good.
All right, so Joseph, do you need to speak with someone from the state?
I would like that, Judge.
Okay. And Lawson it's a criminal trial division. All right, so Joseph, I'm gonna send you to breakout room number 1. And everyone, just give me a
do we have? Judge Boyd,
Yes.
Jim Ultersdorf, we have reached an agreement.
Okay.
With Mr. Scott, Joe Ray Garcia, and myself to, the agreement would be to continue on probation, et cetera. So I don't know if you want us to fill out any forms or not.
Is he pleading true?
Yes, he is.
All right, let's have him come into the main room.
Okay.
Who is handling Terrence Scott?
Joe Ray, Judge.
All right, the court is calling 2016 CR 8204, State of Texas versus Terrence Scott. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Jim Ultersdorf.
And are you Mr. Scott?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Scott, do you have any objection to this hearing taking place by video?
No, ma'am.
All right, the court will find the defendant has knowingly and voluntarily consented to appear by video. Mr. Scott, I'm showing you what's entitled motion to enter adjudication. I'm sorry, motion to revoke community supervision. Did you review that document with your attorney? Did you understand it?
No.
Mr. Scott, did you review this document with your attorney and did you understand it?
Yes, ma'am.
Are you the same Terrence Lee Scott who was placed on community supervision in 2016 CR 8204 for the offense of assault felony second on June 7, 2017 for a term of 4 years? Is that you?
Yes, ma'am.
State.
Violated condition number 1 on or about the 15th day of August 2020 in Bexar County, Texas. The defendant, Terrence Lee Scott, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True.
State waives the remaining allegations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Scott, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement is to the motion, alternative conditions, adding ISF local cognitive and substance tracking. Also adding restitution in the amount of $876.50 to victim Dahlia Agiza, last name spelled Agiza.
And how do you spell the first name?
Dalila. And we are also taking into consideration that theft case, which is cause number 667275.
All right. Is that the agreement, Mr. Oakstor?
Yes, it is, Your Honor. We would earnestly hope that the court would follow that agreement and continue Mr. Scott on probation after the appropriate conditions have been met.
All right, Mr. Scott, are you asking the court to follow that agreement? Mr. Scott, are you asking the court to follow that agreement?
Yes, ma'am.
Chris, not on there. Could she hear you?
It doesn't work. I have to use
None of this one.
Asking if he can hear you. Yeah, she can hear me because it's on.
All right, he just,
Yeah, hello?
everyone stop touching everything. It's fine. I can hear you.
Stop touching it. Okay. Yeah, she controls everything.
All right, so local ISF does not have substantive treatment. So this is what the court is going to do. The court is going to deny the motion, alternate amend conditions to include ISF local, restitution $876.50 to Dahlia Agiza, taking consideration 667,275. And then after local ISF, it's going to be intensive outpatient treatment. There's going to be weekly Zoom reporting or in person until further notice. I'm going to want field visits 2 times per month, random. I'll deduct 40 hours of your community service restitution if you provide proof that you've had the COVID vaccine. Court is not forcing anyone to get the COVID vaccine. However, if you do obtain the COVID vaccine, then 40 hours will be deducted. Mr. Scott, I'm also going to extend you for 1 year. Is there anything else from either side?
Nothing from the defense.
All right, Mr. Scott, each time while you're on this probation, every decision you make from here on out, you need to ask yourself, is this something that could result in me going to prison for 10 years? The big scheme of things, that $800 that you're charged with theft for, you need to ask yourself, is $800 worth 10 years in prison? Right? So that's why we're here, because you violated conditions. We can go off the record, Brenner. You violated conditions of your probation. Right?
Yes, ma'am.
So you need to ask yourself, is $800 worth 10 years of your life? Is it?
No.
So, I mean, you got to wake up and decide to do things correctly. Otherwise, you may find yourself in prison. Because I believe at $800, if you were to do 10 years in prison, that's your $6 a day. All right, good luck to you, Mr. Scott. I'm going to send you to a breakout room. Probation is going to go over conditions with you. And I am going to send you to, let me find where you are. I'm going to send you to breakout room number 2, and probation will meet you there to go over conditions. And Mr. Oberstdorf, you can go to breakout room number 2, or either you can be excused.
I need to get ready for another court in just a few minutes, if I may do that.
Yes, you may. Thank you.
If anyone needs me, just let me know and I'll come back, okay?
All right, thank you. I appreciate it.
Thank you.
All right, Ms. Ferguson, on Wilson Jimenez, who is the attorney for that person, 2020 CR 4098B, because it wasn't on the docket.
Jimenez. Give me 1 second, Judge.
That needs to be recalled for tomorrow. It's discovery issues.
Yes, ma'am.
All right. There you go. Hello. Sure, everyone, just give me a moment. All right, Brenna, this is the last one.
Okay, Judge.
Thanks. Oh, and Deputy Laura, could I see you for a moment, please? Joseph?
Well, I was wanting to see if I could get some information from probation, but I also need to speak with Joe Ray again.
All right,
Please.
so probation is in breakout room number 2. I'll
Okay.
send you there. So do you want to speak with probation first or Joe Ray?
Let me speak with probation first, please.
Hold on, Joe
No,
Ray.
not Joe. It would be, I'll speak with Hunter. I'm sorry, Hunter is who I was speaking with.
Mm,
Joe Ray
mhm.
was the first one. I'm sorry.
I'll just leave it. I'm not gonna make any comments, Mr. Pelt, but
So everyone, my understanding from Norma is that we're going to have to move our shindig. So I'll put that in the chat. Oh, but you know what? Let me check something before I say that. We'll probably discuss that off the, just one moment. Let me look at the calendar.
Hunter, if you're out there, if you could pull me into a room with yourself so I could briefly confer again, please.
Yeah, those notes. Okay.
Sir?
Yeah, if you could, if we could get a breakout room, please, to confer briefly, please. On Lawson.
All right, here's the problem. I don't see your client anymore, Mr. Appelt.
She may still be in breakout room 2.
No, she is not anywhere on the screen.
Okay.
Norma, do you know where Miss Lawson is?
No, ma'am. I don't know where she went. Let me find out.
All right, thank
Okay.
you.
Let me go into the breakout room with Mr. Morrison, please, for while we try to locate Ms. Lawson.
Okay.
Thank you.
I'll send you to number 3. Brenna, the can we push through has turned into a longer push through than anticipated.
It's okay.
All right, this is the last one.
Yeah.
Or we can come back.
No, I'd rather finish.
Now you're like, no, I'm in. You know, it's sort of like when you watch a movie and you think, the movie's not any good, but you say, let me give it a more of a chance, more than the 5 minutes. Then next thing you know, you're in it into 30 minutes and you're like, well, surely it has to get better. And then you're in it for an hour. Then finally you say to yourself, got to end it now, because otherwise, what was all this time for?
Right.
All right, just give me a moment. Well, Brenda, we may have a problem at the jail. Number was informed that they blew the breakers. What that means, we don't know.
Complete shutdown.
Yeah. So we shall see. We shall see. And Deputy Laura came back while I was on my jaunt to see Mom. So she is now back. All right, everyone, just give me a moment. Second. Ms. Lawson, please go to breakout room number 3. Yep, bye-bye. All right, Joseph Appelt, you're back.
I am. I was just typing in chat to let Mr. Morris know what my client prefers to do of the two options given.
All right, is the agreement to have her continue?
That is correct. And Hunter, it's the second option where we're extending 2 years. Okay?
Okay, well, and away we go.
Yeah, well, it's like, well, there wasn't me coming out because I didn't know English.
All right, the court is calling 2019 CR 8173, State of Texas versus Amanda Nicole Lawson. Could I have parties announced for the record for the state,
Hunter Morris.
for the defense?
Joseph Appelt?
All right, and are you Miss Lawson?
Yes, I am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objection from the defense?
No objections, Your Honor.
Ms. Lawson, do you have any objection to this hearing taking place by video?
No, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Ms. Lawson, your previous attorney was attorney Robert Porter. Robert Porter asked that he be allowed to withdraw because of family emergency. Do you have any objections to Mr. Appelt being appointed to represent you?
No, ma'am.
And do you have any objection to Mr. Porter being allowed to withdraw?
No, ma'am.
Mr. Appelt, you were just appointed today. Are you prepared to continue to proceed?
I am, Your Honor.
All right, Ms. Lawson, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review those documents with your attorney and did you understand them?
Yes, ma'am.
Are you the same Amanda Nicole Lawson who was placed on deferred adjudication in 2019 CR 8173 for the offense of unauthorized use of vehicle on November 14, 2019 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Judge. The state would first move to amend the violation of condition number 1. It currently reads failure to identify. I would just add an I in there for clarity. Failure to identify.
All right, any objection to correcting the spelling? State,
No
I'm sorry,
objection to
defense.
correcting the spelling, Your Honor.
All right, you may proceed, state.
On or about the 13th day of September 2021 in Bexar County, Texas, the defendant, Amanda Nicole Lawson, committed the offense of failure to identify in violation of condition number 1.
How do you plead to that? True or not true?
True.
State?
They would waive and abandon the remaining allegations, Judge.
Any objections to the state's waivers?
No, Your Honor.
Ms. Lawson, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Judge. We'd ask this court to deny the motion, continue on probation, but amend the conditions, extending the term for 2 years. Have the defendant evaluated for ISF cognitive track. Order ISF cognitive if eligible, but hold it in abeyance pending the defendant's completion of inpatient stay at Grace
House.
Grace
House, Your Honor.
Okay, yes, I'm familiar with it. All right. All right, is there anything else to the agreement?
The state's taking into consideration the misdemeanor case, Judge.
Do you have a cause number?
It is, I believe, 669460, pending out of County Court 4. I believe that's it, Your Honor.
That's correct.
All right, Mr. Appelt, is this the agreement?
It is, Your Honor.
So is the intention for her to go to Grace House and then go to ISF?
The intention is for her to go to Grace House, and if, I believe it's voluntary and it's not a lockdown facility. So if Grace House is not completed, it's the state's intent that she be ordered ISF.
Okay.
That's a fair summary of what the intention is, Your Honor, that she should go to Grace House, and the ISF cognitive is, in essence, hanging over her head as an alternative should she fail to complete the 9-month program that Grace House is. And she has informed me that she has already been accepted and received an acceptance letter from Grace House. That was forwarded to Mr. Porter. I do not have that, but I take her at her word.
All right, this is what the court will do then. The court will deny the motion. Just one moment. The court, as previously stated, is finding violation of condition number 1 true. The court will deny the motion, alter and amend conditions to include a deduction of 40 hours of community service restitution if she provides proof that she's had the COVID vaccination. Ms. Lawson, I'm not forcing anyone to do that, but if you do it, you'll receive 40 hours credit towards your community service restitution. I'm running referral to Grace House. Ms. Lawson, is someone from Grace House going to transport you from the jail? You're on mute, Ms. Lawson.
Yes, I am supposed to call them immediately upon release, and they are to pick me up and transfer me.
All right, defendant is to be transported by employee of Grace House only. And if you fail to complete Grace House, then ISF. And we're going to extend 2 years. And you're going to need to sign a release from Grace House. I know usually Grace House, that's confidential, but you're going to need to sign a release so probation can see how you're doing there, okay?
Yes, ma'am.
And we'll do Zoom reporting weekly for 2 months. And Rebecca, that's the start once she's at Grace House. And we'll do field visits 1 time per month. And I know that can't be random, Rebecca, because it's Grace House. So if you could just let them know what time you all will want to visit at least once a month to see her. All right, is there anything else from either side?
Nothing from the state judge.
Nothing from the defense, Your Honor.
All right, with that, we'll close the record. Ms. Lawson, you need to do better.
Thank you.
Okay. All right, thank you so much. And Mr. Pelt, thank you so much for standing in.
Thank you.
Sure, Your Honor. I'll get with Norma and whatnot for the appropriate paperwork.
Yes. All right, Ms. Lawson, if you could go to breakout room number 1, please.
Thank you. May I be excused?
Yes.
Thank you, Mr. Morris. Thank you, Judge.
All right. All right, everyone. Where are the prosecutors?
We're here, Judge.
Yes. All righty. So, Brenna, I said we would push through, and now it's 1:16 p.m. But so I will see everyone tomorrow, and we'll be here. I think we're here tomorrow, starting in the afternoon at 1:30. So we'll start tomorrow at 1:30 because I have meetings all during the day. Marcus, it's like you're in the witness protection program. It's dark on your end. We can't see you. What's going on?
I'm in a new location, so the setup is different.
Oh, okay. All right. Well, I will see you all tomorrow. I see people got the memo to wear purple attire. Joe Ray, Michelle, Hunter. Brandon, they kept it a secret from the rest of us.
Yeah, I didn't get the memo, Judge.
All right, guys.